33. The sort for interim. System. This is the matter on 14th in the same state. Yes. Have you informed the other side? You have informed. At request, list the matter. When do you want it? Next week. 45 next week. 55. You have informed the other side. 55 next week. 59. You have informed the other side. So just one. Huh? No, let us see. I've taken a different view. Let us next week. 50. Just 1 minute. Is there any? Okay. Other side. After 2 weeks, you get instruction. Just after 2 weeks, date put. No, get instructions. What is there? No, correct. Somebody will be there, isn't it? In charge. 2 weeks I'll give. You get instruction. Refund matters, you should be sympathetic to them. No, 2 weeks. No, I'm not going to grant a charge. You must get instruction. Refund, you must be sympathetic to them if there's a case. After 2 weeks. 3 weeks. 3 weeks. 22nd. 50. That request is the matter next week.
Serial number 43, my lord.
Yes.
Next week, my lord.
That request.
Petitioner, my lord.
Yes. Given is the yes. This is the matter next week. Yes.
Serial number 43, my lord.
Give it. Cover. Tuesday, Monday. Give it. Give it. Give it.
Serial number 43, my lord.
Yes.
Kindly after next week, appear for petitioner.
Yes, Arjun. Yes, next week.
Please.
आपके लिए टवल ला के रखी थी ना मैं बाहर
No, you correct. No need mark. Yes. One. One. Huh? Yes, you. Now you are seeking for rectification. So you take out notice letters. Yes, customs. Huh? And learned counsel, Jeevan Niralji is directed to accept notice for respondents 1 to 4. Any interim order you have sought? List, list the matter in B group week after next. Yes. Who appears? GST. Central tax. What about 4? Madan Mohan Pillai for 1, AGA for 2, AGA for 3, 3 2. Learned counsel Spita is directed to accept notice for respondents 3 to 5, 3 to 6, 3 to 6. This second only. Now it's what? But your GST refund is rejected. So what is the interim relief? Let us. We'll have it next week. We'll consider consideration of just one. Just one minute. This is seal number 2. In consideration of interim prayer is kept open. List the matter in the orders list next week. What about third one? Rank of respondents is same. So the same order can be passed. Yes, same. List along with the 5-3 of 22. Now both of these can be clubbed. List serial number 3 along with 2 and post along with WP number so and so. Yes. Yes. Council Sri so and so Tiwari. What's your full name? Sushant. SU Sushant Tiwari accepts notice for respondent for the respondent. List the matter. Date good. No. Refund. Otherwise, they come. Refund. You must always be sympathetic. Please. List the matter in the preliminary hearing list on 21st. Now let us see that interim order is passed. So we'll just take note of the interim order because we're not entering into the merits. Correct. Let us. Your just examine. Our counsel Sushal Tiwari accepts notice for respondent 1 and 2. Consideration of you have sought for interim prayer. Interim prayers kept open. This is the matter on date. Yes, motor vehicles. Private counsel Shri M. Kumar accepts notice for respondent 1 and 2. Get instructions. Relist the matter next Thursday. Let us see. Next Thursday we'll consider in the orders list. Interim order yavude orders list ante. Yes. Yes. Income tax has yes, who appears central tax.
My lord, serial number 7, my lords.
Yes, serial number 7.
My lords, I appear for the respondent, my lords. I am here to get instructions in the matter. We posted after 1 minute.
No, there's an interim order passed in a similar case. We'll have it on Wednesday. Have a look at it.
Yes, my lords.
If we have already passed an interim order on same contention, then same order will be passed.
Yes.
You can find your objection. Have
Yes,
a look at it.
Yes, my lords.
Level counsel, Ms. Preeta accepts notice for the respondent. Consideration of interim prayer is kept open. Counsel for the petitioner files copy of interim order passed in WP 15959 of 2021 along with circulars. Same is taken on record. Assignment. This is the matter on 7th. Wednesdays and Thursdays. Thursday. Now, if e-filing is insisted in tax matters, lawyers are comfortable. If e-filing is insisted in, that's why I'm asking the petitioners. If we make e-filing mandatory, have any issues? Because I heard the tax bar, all the lawyers are equally competent and sound. Yes, Chaitanya, what do you say? If we make e-filing mandatory in tax matters, what we could do, there may be some cases genuine where lawyers are representing small clients and they have some difficulty. We'll direct the e-Seva Kendra to provide to ensure that the filing is done. So those who can't, they can avail the facility of the e-Seva Kendra. Others can. Yeah. So just discuss amongst your circles and then you get back. And initially, whether it could be done informally, wherein lawyers start doing the e-filing, and then slowly we'll transition. You discuss and get back. Yes. Next time. Yes. Let us see. We'll have it next week. Let him take instruction. I'll consider your request for interim prayer next week. Next week. Third Council, Sushant Tiwari accepts notice for all the respondents. For the respondents, list the matter on. When do you want? 14th. Consideration of interim prayers, Kyapo. Yes. They have it on Wednesday. Now only on that ground, so it could be disposed of. That Council Sri Dilip accepts notice for the respondents. List the matter in preliminary hearing list on 8th. Only on that ground. If it is so, then let it go back and yes. Same. Yes, 13, same one. Yes. Service tax on royalty. It's covered. Which is the no, just one. Now, Union of India, Madan Mohan Pillai for R1. Third counsel, AG accepts. Third counsel, Neem Kumar accepts notice for the second respondent. G1 for respondent 3 and 4.
Union of India.
Yes. Now the interim order and connected matter at page. Now the notice is issued or order is passed. Against that appellate order, they're here. What is the interim order you have sought?
YouTube में भी live streaming आ रहा है.
Annexure? Cancel. The petitioner submits that the aspect of levying of service tax on mining lease on royalty is a matter that has been considered in interim orders passed in connected matters, including in WP number 24863 of 2022, and accordingly submits an interim order be passed in the present matter also. In light of the contention raised and noticing the interim order passed in WP 24863 of 2022, there would be an interim order staying operation of the order dated 1/12/2021, passed by respondent number 4 at annexure C, and stay of all proceedings pursuant to the said order, including order at annexure D. This is the matter week after next. Or club matters will. This is the matter along with WP 24863 of 22. Yes. Serial number 19. Are the annexures same? C and D. So same order can be passed, identical. Just check the annexure numbers once. No, okay, so same annexures. Same order, same order. Yes. Where is the interim order in connected matter? Interim order in the connected matter. Okay. So we can pass the same order subject to the 10%. So same order. And council's name, Madan Mohan Pillai for accepts notice for R1. And council M. Kumar accepts notice for respondent 2, 3, 4. 2, 3 and 4. 2, 3 and 4. So counsel for the petitioner submits that the contention raised is identical to the contention raised and considered in WP 3997 of 2022, in which an interim order is passed, and that an interim order may be passed on same grounds, on the ground of parity. The interim order passed in WP 3997 of 2022 reads as hereunder. Learned counsel in the learned counsel. Accordingly, there would be an interim order staying the assessment order passed, subject to petitioner depositing 10% of the tax amount as assessed by the authority by its order dated, order of the 9/1/2023, and the recovery of balance amount under the impugned order shall remain stayed till the next date of hearing. Now this deposit is to be made within how many weeks you'll make? Within 10%, within how much time? Within how much time? The amount of 10% is referred to about to be paid within 15 days from date of receipt of the order. This is the matter along with the WP number 3997 of 22. It's 1/23 and order of adjudication dated 6/1/23 and summary of the order dated 9/1/20. Yes. Okay. Passover. At request, release the matter next week. Just 1 minute. Yes. So what is your case? Yes.
one of the reliefs which not okay, brought to a great contract from deadline is I also said earlier, what you have credited by its that is not really when proceeding brought by the purpose for argument for the order not kind of see certain things were granted means by way of following the applying the directives by certain authority. Not in system, doesn't immediately modifies the tax. This is not a policy, finally an article.
Page 50. Yes.
But he rectifies the other states and not adds a dozen. Here he gives me
Yes. Yes.
now, when you say before the application, what I call for that paid returns. That's paid revised returns. Not because for rectifying this, he has additional liability. I will give you this credit. First of things itself, my entire liability is just how about I did this was liability.
Yes, who appears? Third counsel. M. Kumar accepts notice for respondent 1 and 2. Any interim relief you have sought? We'll have it next week. Get instructions. Consideration of interim players kept open. List the matter in the orders list on next Thursday. Yes. Scan again. Service tax. Yes, just you have an interim order. Yes. Central excise and central tax. Third council. So it's accepts notice Union of India. What about the Commissioner of Central Excise and Central Tax? Third council G1 accepts directed to accept notice for the second respondent. We'll have it next week because they're seeking for interim order. It's a no, correct, but on we'll have it next week. Like, this is the matter. The orders list on 8th. And counsel for the petitioner has filed a memo with the case law relied upon, same is taken on record. This is the matter on E. That other matter also raised the similar, which is that matter? So today's list, bill number 7. 7. Yes, 7. Shall we club it or no? Next, let us, bill number 7. This is the matter on E. Let us see. If counsel for the respondent, you find out if it could be clubbed, we'll club it. Similar.
That the authorities and the party not serve again unnecessary event. The order and the party the assessing officer will be upload it is sent to an email ID and KBC.com.
Yes. Next week, Third Counsel Sri Shanmati accepts notice for the respondent. Now, if it is so, we'll have it in preliminary hearing list. That is, this is the matter in preliminary hearing list on 8th. Third Counsel for the petitioner to serve soft copies as well to the counsel for the revenue. Consideration of interim praise kept open. Next week we can dispose it of. If it is so, what he is saying, you verify. We'll send it back. Verify. 149. Correct, but then if there is some ambiguity in the reply that you have sent.
Addition to 27.5 lakhs, 11 lakhs, same date from my wife. 11 lakhs is accepted, then it falls below 50 lakhs.
27 plus 11.
27 plus 11, the assessing officer alleges 53 lakhs. If 11 lakhs is accepted, then the transactions, the deposits which have been made will be below 50 lakhs.
Let us see. I passed one order, just have a look at it. Yes. Page number 190. Yes. Income tax. Yes. You have an extra copy. Yes. 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 No. Yes. 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 Is that an old act? Yes. Yes.
YouTube मामा जी
So it's 4 plus 4 under the old act. 4 plus 4 to 6.
Yeah. Subject matter of appeal for the magistrate. Oh, and in fact, most previous cases, actually not the clear under 149, the very same addition that is already had and then subject matter of appeal. The point comes out of that. There are two additions that are proposed. These are the same addition to the impacted relation by the draft on and extensively discussed the more than 30 pages in the environment of the land. To the right of both of them are extremely discussed among the 100 people. The matter is subject matter of ERP proceedings, now and is beginning activity, or yes, that's same income is already been assessed. There is income escape. Third round by law, first part.
No, just one. Now, under the old act, it is 4 plus 2. Now, the assessment year 31/3/2017. The end of the assessment year 31/3/2017. So, from there, 4 plus 2. Under
Come not get passed. Like our case already, our case comes at 4. 4 is 21.
20. Then we stop at that. Yes. The new provision.
But after 1/4/2021, section after for which of such one of the provisions in 1/4/21 one of the is not has been removed, has been brought under common case. The opening of this stress as such was the rapid of the evaluation.
Then it is protected.
Sorry. I think there is no precipitation. This has been issued.
We'll have it next week, let us.
That's all I'm requiring. Nobody is asking, but I'm making a statement. But I can only inform the officer that it is outside of the I'm making a statement.
Consideration of interim case kept open list the matter in the orders list on
Next time, yes.
consent stream. KB Arvind accepts notice for the respondents. 7th. But substantive, the other substantive grounds,
Other substantive ground that the judgment referred to. That is, because there's a complete.
Yes.
Section.
yes,
What was the issue regarding the judgment?
yes,
One point is
this is the 22. Yes. Yes. Yes.
Touching officer reason to believe that chartered the fact that any assessment here, he may, subject to the provisions of section 1.2, assess and reassess. And also, if the other agent chartered by the fact, this comes to the Indian society, the proper proceedings. Under this, or the law on the because of failure. So here to be our material facts. But I can't see them. There was no failure to disclose. I 21 lots of find that my case, not only will be the reason addition there. By same addition, subsequently search of the found another additional information. No addition in the regard. They proposal is to add the same income.
So this 148 ED is not applicable.
But it is not such a our case is allowed. This case is a demonstration and there is no failure. In my case, I demonstrate not only there is no failure, very same amount, they are not two royalty and kilometer purchases. I show you more than 37 item with your discuss, two part of the petition, where the discuss, there is a matter of number additional amount of taken.
Have a look at it.
Let them have a look. But on this, my lord, yes, very improvements, almost on the back.
Not scanned. Just 1 minute. Yes. Yes, central tax. Given. And counsel. Yes. Yes.
First, but not when we handle spreadsheet.
Yeah.
Not.
Yes.
Reason why this cannot be solved for times from the bottom, which has already been argued, is still an issue of real credits. Based on the turnover declared income tax return of 26 days, to actually examine the minimum service provided, don't examine the income. What happens about normally private is also argued. We have a list of some 9 matters. Income tax return. Use the focus on showing those figures. Confirm the order gets without looking into the take the tax. Find out these things whether one is exempt, which is requirement of payment. Or for example, in some of the cases, advocates are including those who are seeking lots. They have been issued notices saying reverse charge mechanism. Much of these matters.
So for the purpose of service tax, merely they rely on income tax and proceed.
Yeah. There is no service tax. If you wanted that as a service tax. Jurisdiction extend to pay income tax return. Simply issue notices and confirm those orders. Without complaining your mind whether the service is there or not. That is the crux. In fact, this extends to any number of cases, not there because of where it is focused. Can't take the income tax return blindly subjected to tax under some other place. It's a settled law. Has already seen this order.
Yes. Yes.
183.
Central tax G1. This is a past and interim order on
All these matters are part of the past. Strictly 180 it would be not recorded better
I messed up. I messed up. I am messed up. So the interim relief you are seeking is a stay of we can club all the matters. Furnish the numbers.
The list of numbers I have.
Give it to me. We'll have it on 8th because two other matters today as similar contention we've had it. That day we'll club with the further matters and then fix a date. Yes. Yes. And senior counsel appearing for the petitioners submits that the improved order passed is liable to be set aside on the in light of liable to be set aside and submits that for the present interim order may be passed taking note of the order passed in WP 15959 of 2021 wherein this court has observed as follows the reproduced page 183 compilation. Accordingly, noticing that an identical contention has arisen in the present matter also, there will be an interim order of a stay of operation of the order in original at annexure B. This is the matter along with WP numbers also in the orders list on 8th. Petition is filed. Notice for the first respondent, VGA, accepts notice for the second respondent, M. Kumar, accepts notice for the second respondent. And this is the matter. Let us see, let him get instructions. On 15th in the orders list. Orders list. As of 15th. 15th. Yes.
Which other accounts? In part, in trial of sanctioning authority is specified in the law section of the Yes, it is a law, the law, not the law. So called 51. The law will find it at 60. Page 137. See approval. Last document is scrolled down. Yes, at page 139 as well as 140. Last doesn't clear its nature. Either digital or not.
The order of approval. You have a extra copy, you can.
The validity or utility. Approval is knowledge. The approval is knowledge. The order of the 148 private fee is in mind. Nothing in mind. What is issued under section 148? Because that is safe. Also in mind. Ground one. Another ground. That is not notice. The assessment here is 16. After the new regime of the assessment, section of 49, the time limit is telecast. What is the new tells you? Ordinarily by default, by exception, the 149 subsection 1 clause B. If income escape is assessment,
Then chargeable to tax.
income charge for it. Escaping assessment. Basis of books of account or other evidence, whether it's just represented in the form of the asset of an expenditure or an entry in the books. That can be seen for 10 years.
Up to that.
49 monthly. Subject to further protection that the contrary over beyond 6 years. But also first cover to 49 monthly. If it
Under the 148 AD order, they don't,
there is no such made. One eight years practice. Some government. I guess not community part years.
so that you can reply to that and then they can pass an order. So that you can make out a reply, putting out forth your case, and then they could pass that order under 148 AD.
This is moving me from the default regime to something that is not convenient. Not the new regime.
That information must relate to the ground that is available for extension.
Without not just the real regime law. Up to 4 years, if income escaping assessment, targeted tax escaping assessment, not existing. Just the limit of income was specified. Now you know what this is. It is not just 50 lakh. 50 lakh, that income targeted tax escaping assessment, on the basis of contract and corporate government. Represented as the form of an asset. The form of an expenditure. Form of the rent, the book of account. So there are specific requirements, which requirements will have to be our two and established. But not then staying in the regime of 10 years and 3 years. Now, most of this effect on all these issues. Yeah, what is it? Number of Independent model will not fail finding. Will not find concept by weakness. Not only, other than the 151, which is my first principle. The other weightage, the approval was different. If the approval is unsigned, which is knowledge. And not ready to last week, we did notice that lot the issue of the case where it would move from the default regime, extended regime of
Other petition is of different SSC, same SSC. Yes. Next year. Yes. Page 140. Yes. At page 1. At page 141. Refer to attach. Yes. We'll have it next week, let us.
Another problem, which is assessment here, 1670, 1516. However, the law, requirement of pension is not met. Requirement of pension is 50 time of so evidence is the representative in the form of assignment. That's the ongoing push. So the laws clearly stating that never at some time in 1560 for no property transactions are taken place, not stating the further and assigned in expenditure. This is what the most likely case. It's no problem.
Yes.
All notice and exception for changes. The relevant assessment. A. 3 years have elapsed. End of the relevant assessment. Unless the case falls under clause B. So therefore, it is to be demonstrated by the reason that my case comes under clause B. Otherwise, it gets elapsed. Now, you know, clause B. 3 years, but not more than 10 years have elapsed. From the end of the relevant assessment, unless the accepting outcome as in this procedure, books of account, other documents are evidence which reveal that the income chargeable tax represented in the form of expenditure and entity. Each of the case amounts to the likely amount of 59 rupees. This is a requirement. At the indicated into dollar. I will take my notes into dollar. The hundred front transfer to be there is no reference. 149 1 within front B. It starts at grade 141 now. Nothing you can do. In the case of sale of one property, there is a case of purchase of another property. They are not even indicated what is the lots of recently delivered judgment. And it is not the sale value, it is just the income that is to be taken into consideration for limited 50 years. Here, they are not even indicated. They have said what is the sale value, what is the purchase value. So, therefore, the laws, you have to identify how much of income is kept as a and evidence to that. To establish that it is represented in the form of optional history. So, it cannot be
In your reply, you have detailed regarding these two transactions. In your reply,
that is another principle which I did not argue, not thinking that this verification is quantitative. Another principle is the first notice at a 1.8 is that now the wrong text. Portion document described by course. Object of the group is the next chain. Which is the next chain. It will understand report. That is in page 130. That is on the fifth of the rule. Not to understand the appreciate one more small factor. Assisting is a non-factor. It's not a regular income factor. Also, a family. There is no other income except these two transactions. Which is case the hold on agricultural land and invested in another agriculture. I will not borrow the funds and wait because of this part we can not have the but except saying that there is a role of related section 54. Where land goes for agricultural purposes, good land in application, another land, there is no application activity. I will not borrow the land for the land.
the reason why that question may become relevant is one of the matters. The sale transaction was reflected in the annexure. Sale transaction was reflected in the annexure and notice was sent. The SSC has given a reply detailing that since it was long-term capital gains, the cost of index, etc., and then came to a calculation that it was less than 50 lakhs. So, if in the reply that is made before they pass the 148 AD order, it is pointed out that it comes outside and it's not income chargeable to tax like what you are seeing now in your case, then is it not that the department is then when passing order under 148 AD to advert to that reply and then come to record a finding that it is income chargeable to tax falling within that for which the extended period is available.
Yes. Delivered by post. And all assets is not even registered in the court and you would even have to know it. They will not send, they will transfer a case. So they resend the notice. From the end of February, it will not be mandated by one day.
It didn't work out. Next year?
This also is. They did the same thing. Without technical cost. Therefore, assessing not even know the district. Earlier notice is not required. You kindly send it. It is also stated that please have a lot of notice in second paragraph. You are requested to register your bank and e-filing website immediately and respond. Which may not be come on 14th March. That becomes the law. In annexure G, which may not be mandated by 146.
Yes.
On 21st. This is on 21st. And not when you were written down remarks or responses. Then we want to assess the event. The state is and then there are like to compile the information that is clear as well as the statement should ask the commitment to change in address for validation and address as per data of this not by address. All of these are not received any notice. Are received the notice by registered email. Now I am compiling furnish the details so that I am requesting only that submit pages related from the 8th of March. If the lots, the other asset officer, I will not see the notice in given annexure B at 148 then I am not going to give you 10 bucks and warrant, which is completely incorrect. When I ask for time and extend the time, whatever time that is given to me, as much extended time is given to me, we can exclude from the limitation. What purpose of the party? Conveniently chooses here, not clearly. Despite me clearly making a request. This could have been a simple case where man could have gone back. So I want to understand. That was the reason. Proceedings will have
Let us see. Let him take instruction. We'll have it on next Wednesday. Yes. Yes.
Yeah, that is first order has been first very probably.
before this order.
What is passed on? What is passed on 24th?
What we A, B, description of course for a genuine reason. If it is PI on 14th of March, till then no real-time alert was sent. It is just put on to the portal. Crucial melodies, it has to be sent to a registered code. Our melodies, it has to be put into portal with a real-time alert. Otherwise, how would anyone know if it is in the portal? I cannot stand glued to the computer always. That's what melodies. Six.
We'll have it next week and we'll see what can
I
happen.
have real this itself is knowledge because approval is not taken. Unless you find that if I don't find return the lots, I would have refund. The next.
That means let us see till next week. Next week we'll decide what is whether we are going to send it back for fresh consideration. Let us see. We'll have it next week.
It's better the situation back. An unsigned approval existed. Nothing for the issue. Nothing for the issue is second. Conflict one was supposed to be important. Now, allow the court better to say that it becomes my case is better. As of now, also no signs of this person. In this case, first it was unsigned approval. On the basis of the 148 is part. Approval got second. So, contrary to what the level is saying, it is not a curable difference. The incurable infirmity was the root of the cause, the requirement is part of the
Yes. Get verify from it. That concerns to Sanmati accepts notice to the respondents. It is submitted on behalf of a petitioner that as on date, the order of approval is unsigned. Various other contentions have been raised, including that sufficient time was not given for replying to the notice under 148B. The respondents are directed not to precipitate the proceedings pursuant to the order under 148 in the next date. This is the matter on matter 15. Now you'll also just think about it. In many of the matters, you are taking the income escaped from assessment, that one. So it's better that you look at what the position is. Here, the courts are holding, it should be income chargeable to tax. And then the order under 148 AD can contain the ingredients of 149 1B. Let us see on the next date. I'm prima facie inclined to send it back, giving direction to record a finding on this and rehear it. Let us see. On the next date, you make a submission, we'll see what we can dispose it of on that date. The next year, they've said not to take any precipitative action pursuant to the notice under 148. Yes. Who appears service tax? Central tax. Given is right to accept notice for the respondent. We'll have let him take instruction next week. We'll consider the request for interim prayer. He's not there. He's not keeping well. So by next week we'll ask him to get instruction. We'll decide it next week. No, we'll see we'll have it on next Wednesday and we'll pass an order. On next Wednesday, we'll pass some order on your interim prayer. Let them take preliminary instruction. Now, tell me now, make out your case. Yes, make out your case. Make out your case. Rule 6A of service tax.
Yeah. नहीं हो पाएगा। I will.
No, just 1 minute, just one. Hello. Service tax. Yes.
And you know, outside India. That means I have provided a service outside India, that is China. Actually, which dollars in the US stock exchange. Actually,
Yes.
Actually, it is bank statement. Payment of that is not actually cannot of foreign country. What kind of city? Here, I say,
Right. Last 9,900 US.
Yes.
Action. Here, back of the issue. Remittance. Foreign legal remittance. Where bill number 4. I have looked parliament. I have repeated the China.
So there is some rebate or exemption. Is there any rebate or exemption? Where do you get that? Where do you get the exemption? Where is it? Huh? No, where is the exemption? I'm saying? Which provision provides for an exemption?
State circuit provided. How can a state circuit provided? That's one.
Where is the exemption? Where is the exemption?
My service is outside the country. There number expert service outside the country. There is not liability.
Under 6A subclause 2, central government notification should be there granting rebate under 6A subclause 2. It says where any service is exported, central government may by notification grant rebate. That you will have to show which is that notification of central government granting rebate. That, where is the exemption you point out? You have to point out that this export of service is outside the purview of the service tax. Then I'll consider. We'll have it next week. Let him come back with instruction. Third Council Jeevan is directed to accept notice for respondent. Yeah, Deputy Commissioner of Central Tax, Jeevan, is it? For the respondent. Consideration of interim payers kept open. This is the matter on next Thursday. Yes. Copies of the petition to be served. Yes.
My lord, serial number 28, I appear for the petitioners, my lord.
26. We are at 26.
Sorry.
Yes. We'll find out. We'll have it on next Wednesday or Thursday. Next Thursday. Relist the matter in the same stage on next Thursday. Yes. It's a fresh matter, is it? Fresh matter. Just one minute, just one. Commissioner of Central Tax. So who will take notice for the respondents? Yes.
My lords, I'll take notice for respondents 2 to 5, my lords.
Sections 5. Union of India as an additional respondent in light of the submission made and taking note of the government's application. Who is there? Union of India? Anybody is there? Notified. So far as the Union of India is concerned, application is allowed, copies to be served. Yes. Necessary amendment to be carried out. Now for the rest, that also Kumar accepts notice for the first respondent. 2 to 5. Five. Consideration of interim orders. This is the matter on next Thursday. Orders. Serve copies.
Number 28.
28, my lords, I appear for the petitioners.
My lords, I appear for the respondents in the matter, my lords. My lords, this matter is similar to the one that was heard yesterday, my lords, with regard to refund of the amounts paid at the time of investigation proceedings. There is the present petition is also filed on similar grounds, my lords, for refund.
Yes, yes, petitioner.
Yes, my lords, I appear for the petitioner. This is a matter whereby it is covered by the decision of this honorable court on 24/3/2023. The respondent number 2 to 4 conduct a raid on the petitioner, and on the very same day, during the course of the raid, a 10 crore rupee is being coerced by them, by the respondent number 2 to 4, to make voluntary payment. And thereafter, on having made voluntary payment, my lords, it is their claim, that is respondent number 2 to 4, that this is a voluntary contribution which is made by them, and they are not even issuing any notice. They have not issued any notice prior to that. Neither have they issued any notice after that. And my lords, may kindly have page number 78 for a moment.
My lords, I need 2 weeks time to file my objections in this matter, my lords.
If I may just make one submission, my lords, the judgment starts at page 64. It's a division bench decision of this honorable court, page 15. It is the points for consideration. It says, may I read, my lords?
Paragraph.
Paragraph number 15, 78.
Para?
Para 15, page 78.
Correct, but now this has to be demonstrated.
Please. Now, my lords, apart from that, my lords, there is an page number 95. There is an order of the central government that during the course of investigation or on the day of the seizure, there should not be any voluntary contribution. If the person or the assessee wants to make any voluntary contribution, the respondents have to inform him to make voluntary contribution on the next day. On that very day, there should not be any. Only to avoid this uncomfortable situation, my lord, this orders has been passed. Now, my lords, may kindly see this order, this honorable division bench order, my lords, which I am referring to, is of Swiggy, my lords, which had paid 12 crore rupees on the
I
day.
passed the first orders by me.
Please.
Yeah.
Now, my lord, if I make one submission, my lords, this division, honorable division bench.
No,
of this-
correct. I'm aware of
Yes,
it.
my lord.
Now let them file their objections, and
Please.
then we'll decide the matter. Let them file their objections.
If I make one submission, my lords, see, 10 crores is stuck with them.
Let us see.
Then date may be fixed in the next week, my lords. If they are not unable
My
to
lords,
make
only
any
2 weeks time, my lords. I have yet to get instructions, my lords. 2 weeks.
lords, they are holding my 10 crore rupees.
We'll
Let
see.
them
We'll
refund
fix a
9
date.
crores.
We'll fix a date.
Please.
Now, all that correct. All that has been considered in the division bench judgment. Let us see. So it's a fact. So let you file your objections. That's a factual assertion which you will have to place on record. Yes. That was the case also in the division bench matter. Wherein, that we'll see. You take your stand. You take your, because it's a factual assertion you'll have to take, you place it on record. And have a look at the division bench order. The respondents to file their objections by the next day. Now you appear for the Union of India. Who appears for the other respondents?
I appear for the other respondents, my lord.
Preeta. Third counsel Preeta accepts notice for respondents 2 to 4. The respondent 1 as well as respondents 2 to 4 to file their objections by the next date. This is the matter, week after next date. On 21st, in the same stage.
Interim order may kindly be extended.
What is the interim order?
Not to take any precipitate action against us, because they are coercing us that we will arrest you, even if the writ petition is filed. That's the reason this interim order is granted.
My lords, the arrest proceedings have no relation to this, my lords. The arrest proceedings will happen if there is,
there is a
cause
judgment
of action, my
which
lords.
says that
No
without
relation
any
to-
prior notice, they can't even arrest me.
Without a notice, they will not arrest, my lords.
Then
There
let
will
them
not be any-
undertake, my lords.
Of course, without notice, there will not be any arrest, my lords.
No precipitative action may be taken, my lords.
My lords, that's only civil in nature, my lords. Criminal proceedings cannot be.
132, they have a right that they can arrest me. If it is more than 2 crores, it is cognizable and bailable. If it is more than 5 crores, it is cognizable, non-bailable.
The council, the adjudication cannot be kept on hold. This
No, they are
amount
not
of
adjudicating, my lords. They are not adjudicating.
My
If
lords,
they are
adjudication proceedings,
I will undertake.
investigation
Why will they
proceedings
adjudicate?
are ongoing,
Just
my
one.
lords.
Just one.
It's not that
Now, why-
show cause notice can be issued immediately. Investigation
No,
proceedings
if they are
ongoing.
giving me a notice for adjudication, I will board
My
on
lords,
my lords, I will
investigation
attend.
proceedings are ongoing. A
Coercive
show cause
action should not be
notice
taken.
issued in due course. They cannot fix timelines on when a show cause notice has to be
Lords, if
issued,
I may take
as
1
long as
minute,
it is
my lords,
issued
without,
within the timelines prescribed by the law.
lords, if I may take 1 minute without the interruption of the learned counsel for the respondents, my lords, the precipitative action was sought in the first instance because they were ready to arrest us without giving us any notice. If they give us any notice, I undertake, my lords, that we will cooperate.
My
If
lords,
they were
if there
to
is
give
a
any notice,
requirement in law
but
to
they
give a
cannot,
notice, there
they
will
cannot
be a
take my
notice.
10 crores, they cannot threaten me with arrest, and they will say, my lords, the threat of arrest, in my writ petition, I have mentioned this, but they are saying that even if I were to initiate writ petition, even if I were to take recourse of law, that they will arrest me.
My
That is
lords,
the reason we have taken this interim order.
my lords, if the law warrants that an arrest has to be made, my lords, it has to be made just by filing a writ petition for refund of the amounts paid during the investigation proceedings. The investigation proceedings cannot come to a stop. They are saying that a show cause notice has not been issued. Adjudication proceedings will be taken up in due course once the investigation is complete. And if an arrest is necessary in the investigation procedure, that also has to take place.
My lords, they are not even issuing me notice till date. My lords, from the 22/4.
Notice will be issued only after the conclusion of investigation. No
Let
notice
them
before that.
investigate. Let them investigate. I have absolutely no problem. But they cannot arrest me or take any coercive action against me. But
Why
if
not?
there are any
Where is
adjudication,
the
I will
restraint?
go down.
No. Where is the restraint for arresting you? Where is the restraint?
Restraint
No
will be in
restraint.
section 132, my lords. My lords may see 132 of the GST Act.
Council, you can't push it too far. Under 73, 74, they
Yes.
can go ahead. That we can't
Certainly, my
prevent.
lords. They can
This
go
will
and give me a
see. This will
notice.
see separately.
They can give
You
me.
can't prevent them from carrying on their
My lords,
further
I am not
investigation.
asking them to not carry on the investigation. 132 may kindly be for you.
My lords, 132 is not a subject matter of this writ petition, my lords. They can't
If I may
introduce
just, I have not even completed my arguments. I would request the learned counsel for the respondents to hold the horses until I finish, my lord. 132 states there are three categories. If it is 0 to 2 crores, the GST evaded says that it is non-cognizable and bailable. It is a non-cognizable offense. They can't take cognizance, they can't register an FIR also, they can't do anything without permission of the court.
No, this is not the case of what's a offense investigation.
Well, Lord, certainly. Now that they have asked me to pay 10 crores, coerced me to pay 10 crores, they have taken
That's
the
a
10
different
crores.
matter. That's a different matter.
Well, Lord,
That's a different matter.
I appreciate. But if they have taken the 10 crores, that means to say, if they have come up with, I have evaded GST more than 2 crores or more than 5 crores, it will become a non-bailable offense.
No.
To that
This is
conclusion.
power of arrest during investigation has nothing to do with offenses cognizable, non-cognizable, etc. During the process of investigation, they have the powers. I am not going to
Certainly.
hold. I am not going to restrain the investigation. That is independent of
But
the
it may be
refund.
clarified that my lord's investigation is unbridled. It may be clarified that it is not restrained. But my coercive action against me should not be taken because
No protection. No protection. I am not going to grant any protection. You are not entitled for any protection. That in the investigation, you take anticipatory bail, whatever you want to take, you take. I am not going to pass. This how can we pass? No, how can we pass in this writ petition an order restraining arrest? That cannot.
Only coercive
You take
action.
anticipatory bail. You take
Only
anticipatory
coercive
bail.
action.
I'll keep it open. No. I am not going to restrain that. This is a
Otherwise than in
only.
accordance with law, my lords may clarify. Otherwise than in accordance with law, and my lords may clarify that investigation process may take place.
Yes.
Also may be that also may be clarified.
It is.
But only coercive action, otherwise than in accordance with law, should not be taken.
Yes. The objections to be filed. It is clarified that investigation could be proceeded with while further stipulating that any coercive action must be strictly in accordance with law. Yes, this is the matter on. But I'm making it clear, if I find, like in the Swiggy matter, that you have coerced them, you are going to be levied with exemplary cause. The division bench and the single judge have gone, you have a look at both the judgments, and same contention was raised that they may have paid voluntary, etc. Findings have been recorded with the direction to refund. If I find the same thing or any element of coercion and then describing it as voluntary, I'm going to impose exemplary cause. Last time we have heard the matter on merits in detail in the other two matters. Copy of the division bench order is there. Please look at it. Yes.
Obliged, my lord.
Yeah. Why has it come today? There is tax roasted. There is a tax roasted. We'll have it on Monday. On no, we'll direct them to take notice. That we'll see. Not in this case. Now that we'll see. Huh? No, that we'll see. That we'll see. VDR 1965 acquisition. This is all settled. 27. No, look at Justice Arun Mishra's judgment in Shivram Karant layout. There's the end of 27. We'll see. We'll see. Take out notice. Third Council Shri M.V. Charadi is directed to accept notice for respondent. 2-4. AG is directed to accept notice for the first respondent. Serve copies on the on Murgesh Charati for request for interim prayer is kept open. This is the matter on Monday. You have a look at what is the scope of 27 after looking at the judgment of just. Now in the denotified they want to do. Then why have you sought for lapsing? Correct. Then why do you ask for lapsing? You rectify your prayer. Rectify your prayer. We'll have it on Monday. Let us. 290. Yes. Yes. Let us see. We'll have it on Monday. On that day, I'll listen. You serve today itself on the standing council. It's the matter on Monday. Income tax. Land Council Sanmati accepts notice for respondent 1 and 2. Annexure. Give him a copy. Give him a copy. Yes. One crore. Yes.
fact is, I don't have any demand for the others. I think they say that the demand has demand for the recipient government and I said the bypass against taxes. There are no demands. This refund demand has been adjusted against those years ago. All that I am seeking is mandate of the Russian direct to refund this amount.
Find out, find out. When do you want?
Verify the records.
It's the matter in preliminary hearing list, 2 weeks admin date. You take instruction if it is so. If you file objection, there's something else, then I'll put it in P. 15th. Preliminary hearing. Yes. Petitioner to serve soft copies on counsel for the revenue.
Yes.
So why don't you all start do e-filing, whoever is possible? Wherever it is possible from your end, I'm voluntarily requesting before we make a, whoever is possible, you do it. There's some, you just find out, let us see. They're saying some, correct, they're saying there's some requirements that it has to be, some format is required. Annexures are not delineated, etc. Some issues with that. Find out. Pass over. Just told me, G1 is not, G1 is not keeping well. We'll have it next week. Let him come. This the real is the matter. Next week. Yes. Date 1. 8th. We set aside. What are the facts?
The guy does this all. That is absolutely
148AB notice was not received by you.
I saw the one thing.
So only on that ground we said it is that 148AB notice was not served. So correct. After the 148AB notice, he gives his reply, and then you pass 148AD, isn't it? So that 148AB notice was not served on that ground. No, he's saying he's a non-filer. That is your. So that 148AB notice was not served on you. The impugned order, what do they say? No, in the 148AB order, annexure AD order. Aga? So we'll only say 148AB notice was not served, and he'll be given a fresh opportunity. That 148AB notice is at annexure the petition. Let's find the present petition. Seeking for setting aside of the order under 148 capital A within bracket B small d of the Income Tax Act dated 28/2/2023, and the notice under 148 at annexure B and the notice under 148 dated 7/3/2023 at annexure C. The principal contention and has sought for certain other allied reliefs. The principal contention of the petitioner is that the petitioner is a non-filer of returns. Where have you stated that? As is asserted in the averment at para 1 of the petition. It is further submitted that despite assertion to the contrary by the revenue, no notice under 148 capital A within bracket B of the Income Tax Act was served on the petitioner and in the absence of which the authorities have proceeded to pass an order under 148A within bracket D of the Income Tax Act and proceeded to issue notice under 148. It is submitted that there was no opportunity for the petitioner to make out a reply to the 148A B within bracket B notice, and accordingly all proceedings thereupon being in violation of principles of natural justice ought to be set aside. Next, you have instruction. Third Counsel Sri Dilip upon instruction submits that the petitioner may be granted another opportunity to reply to the 148 capital A within bracket B notice, and proceedings be permitted thereafter. Now you have a copy of the notice. The next, in light of the said submission made on behalf of the revenue, the impugned order under 148A-D at annexure B, as well as the notice under 148 at annexure C are set aside. Matters remitted for fresh consideration from the stage post 148A B notice. Petitioner to file a reply to the 148A B notice within a period of 3 weeks from date of receipt of this order. Department is liberty to proceed thereafter in accordance with law. Accordingly, the petition is disposed of. Yes. At a request made on behalf of Counsel for the Revenue, relist the matter after 2 weeks. Yes. Uh, 23.
Yes. Yeah.
For a penalty order. Then we'll dispose it of. Scan again. Huh? petitioner, it's a primary agricultural cooperative society, has challenged the has sought for issuance of a writ in the nature of mandamus to direct the first respondent to dispose the appeal at annexure D within a period of 3 months and not to make any demand in the interregnum. Further, petitioner has also sought for appropriate direction to the respondent to pass orders on the application for stay dated 18/4/23 and in the alternative to direct the second respondent to consider the application dated 19/4/23 at annexure F and to keep the demand in abeyance till disposal of the appeal. The admitted facts are that the where is the assessment order annexure? The petitioner had filed its return of income for the assessment year 2021 and claiming deduction and accordingly has declared the total income as nil. Assessment order has been passed at annexure A and the order levying penalty is passed, copy of which is enclosed at annexure B, and notice of demand is enclosed at annexure C. Next. It is not in dispute that petitioner has filed an appeal on 18/4/2023 against the order of assessment at annexure A against the order imposing penalty. Next. It is submitted that a statutory appeal under 246A against the order of assessment has also been filed on 16/4/23. Next. It comes out from the narration of facts that application seeking stay of demand has been filed on 18/4/23 and 19/4/23. Copies are enclosed at annexure E and F. Next. The counsel for the petitioner submits that no order has been passed on the application seeking for stay either against the assessment order or the penalty order. Against the penalty order. Lord Counsel Sri Sanmati submits that appeal would be considered in due course, taking note of the seniority of the appeal as against other pending matters, and submits that in the interregnum, the order in penalty may be directed to be kept in abeyance and there would be no recovery till the appeal filed by the petitioner is disposed of. Next, accordingly, petition is disposed of, directing the respondents not to seek for recovery or enforce the order of penalty till the appeal filed by the petitioner is disposed of. Now, the writ is only against penalty order or also recovery? Both, both. Accordingly, annexure B and C are kept in abeyance till the correct. So the question of recovery is not a subject matter. Abeyance, and the respondents are restrained from enforcing the order of penalty till the appeal filed by the petitioner is disposed of. So recovery, I will keep quiet only on the penalty of that. Okay, I'll correct that. Yes, yes. Once in the sentence, restraint is only insofar as penalty is concerned. ಏನಾದ್ರೂ ಮೇಲೆ ರಿಕವರಿ ಆಫ್ ಟ್ಯಾಕ್ಸ್ ಅಂತ ಇದ್ರೆ ಅದನ್ನ ಹೈಲೈಟ್ ಮಾಡಿ ಅದು ಸ್ಕೋರ್ ಔಟ್. ಎಸ್, actually, but it should not come back before the court. This, if it is possible, whatever other relief you are giving, give it in this answer. That I don't know what difficulty they'll have. The petitioner, learned counsel Shri Sanmati accepts notice for the respondent. The petitioner, which is a primary agricultural cooperative society, has sought for issuance of writ in the nature of mandamus to direct the first respondent to dispose of the appeal dated 17/4/23, marked as Annexure C, within a I show it image. Here, in one order, the two orders is this. Yes. The Commissioner has Next. In the alternative, petitioner is also sought for issuance of a writ in the nature of mandamus to pass orders on application for stay dated 17/4/23 marked at Annexure D and pending consideration of the appeal and application for stay. Third respondent be directed to forward application dated 18/4/23 to the second respondent to enable him to consider the same within 4 weeks. It is noticed that as against the assessment order at Annexure A, petitioners filed an appeal before the first respondent under section 246A of the Act, and the said appeal was e-filed on 17/4/23. Next. It is submitted that though application seeking stay of demand before respondent 1 and 3 have been referred on 17/4/23 and 18/4/23 at Annexure D and E. The said respondents have both the
That two applications seeking stay of demand before respondent number 1 and 3 have been put on 17/2023 and 18/2023 at Annexure D and E. The said respondents
the said applications have not been disposed of. In light of the facts that are made out. Next, learned counsel for the revenue submits that necessary steps would be taken for disposal of the application of for stay at Annexure D, Annexure E, at Annexure E, pending before the appellate authority, pending before the assessing authority, would be considered expeditiously, which would take care of the grievance of the petition. Next, in light of the said stand, petition is disposed of. The respondent number 3. The respondent number 2 is directed to dispose of the application for stay at Annexure E within a period of 6 weeks from date of receipt of certified copy of the order. Needless to state, till then there would be no coercive proceedings initiated pursuant to the assessment order passed at Annexure A and the demand notice at Annexure B in light of the appeal filed by the SSE is pending consideration. So then we'll dispose it of.
Application is ready for the month. They are numbered in separately and given about 11 numbers. The security guards for the outhouse, they've all been numbered separately in the application. The order of the outhouse is 41, 11, and also. Direction is regular rates. We see the 41 and 43. Line refers about excellent. But then directs, the action is directly required behind. Then para 11. We directly behave to regularize the metrics specified instruments. And then we directly behave not to require or take possession of the land or building specified in the nature L and nature N. So land and buildings. Now my property law, just so that but there's no ambiguity. Page 74. Number 2483. Survey number is the type residential without approval. 6485 square feet is the built up as I might record. And then the total site area of the entire land of 5 acres. So now in light of my learned friend's submission, which is with the order yesterday, the regularization of the land is to take place. The only question is not what happens to the other buildings that are standing. They have, if you want to just have a look at page 304. No, I felt the composite application. 604 words. For the pump house, servant quarters, etc. They have numbered it as 11 applications. 304 words. I filed a single application. There in writing, they have numbered it as 1 to 11 with different cases numbers. Now, my apprehension before your lordship says, in respect of the other JCC number, we have received this SMS from the committee saying that there is no approval from the Supreme Court when there is no such order. Therefore, my very respectful submission.
Justice. Now, this see at page 304, that application 1 to 11 are all falling within the ambit of the area, this area, is it?
Yes. 6,000, not say, this is a residential.
Which are the applications which are rejected?
4923 onwards.
Yes.
Serial number 2 to 11.
2 to 11.
Now there is no rejection order. It's not the rejection that's the area or the building which is regularized is recommended to be regularized. The remaining area for applications are recommended to be rejected for several reasons. Some in that way, first application 04918 is the one pertaining to the residential house. In total, is recommended to be regularized. Yeah, everything they are done.
paragraph 9. In paragraphs 10, 11, 12 of the report, so committee has recommended regularization of water buildings contained in section 125 buildings, number so and so, section 38 buildings, serial number so and so in section 50 buildings in section A, and 40 buildings. For the reasons stated that these buildings are required to be regulated in terms of our other regulated.
Now, do we have a copy of that report? The 13th. All this is a part of the 13th report, isn't it? 30th report. In the 30th report, the annexures, if you have a look, that may clarify.
Part of the
Page?
okay. The report. It is part of this report. When your lordships get annexure M, 48 is annexure L. Annexure M, which pertains to me, is at 74. As I submitted earlier, lords, it refers to the built-up area as also the cited area.
Correct. Just now in annexure M at page 74, there's a reference only to one application of yours.
But it refers to the entire cited area.
So what happens to the other? Now in annexure M, you have application number 04918.
This residential unit, another building of the land.
But the direction notes is not to acquire the land. That's the note that
Pertaining to that building.
that is something that has to be clarified by the just the order once again. The direction at page 44. We direct the DDA not to acquire or take possession of the land or building specified in annexure L, annexure M. Now in annexure M, there is a reference to the land, the entire cycle area.
But in the order, the serial numbers don't tally with the application number.
So that
Both the annexure.
application referred. My respective submission process in respect of the other applications that they have broken up, other end, they are required to file a further report before the order and take some order. In the meanwhile, kindly protect it till that happens. Because other than an SMS, I have not been hurt by the word. There is no speaking order passed. And in similar circumstances, this honorable court once has made an order asking for the report to be placed before the honorable report till such time status before the government is accepted.
Contains the entire report of 3011.
And then everyone
So the plan of the
that has to be placed before your lordship. We are not privy to any report other than what is at annexure A. Just need this order note that I have placed before your lordships now.
for the only for see cycle area and recommended for regularization and accepted. I understand that we are.
No, the otherwise, the other way of doing it, looking at it is insofar as remaining applications. I reserve liberty for you after noticing that there is some ambiguity to seek for clarification.
For the orders. Yes, Lord, which is what has been ordered. This order that I placed before your lordship is. I request the Lord to protect me then. Till such time I am able to move this Supreme Court. Right now, Lord, this Supreme Court is on vacation. Just see the direction at page 29, Roman 5. It is further directed that till the VDA bar the Justice Special Committee submits a report to the Apex Court in terms of its orders dated 3/12/2020 and 5/5/2021, and until further orders are passed by the Apex Court all parties are directed to maintain status quo in all respects in respect of the
Correct. No, so, but what I was contemplating is now there is some ambiguity. I'll notice that ambiguity and then say that a clarification that you will seek for clarification in that regard and leave it at that. Then extend the protection. There in the Supreme Court, you get your clarification.
So the interim, if I face demolition, it's a failure of because I'm not a party. I will then have to first make an application to intervene. That can only be after the vacation when the matter comes before the goes to that. Therefore, my very humble.
No, I'll observe that. I'll observe that insofar as the other serial numbers, this is their submission. But there is some ambiguity because the order says annexure M. However, BDA submits that they have placed the report and orders are passed. So till some time immediately after summer vacation, I'll give some limited protection so far as the other serial numbers. Only till some 2 weeks after summer vacation.
Facts of that case. If there's any order that might have been case, show validity.
No, sir, there is only in light of summer vacation to the Supreme Court, and for 2 weeks are reopening. After which it's for them to get whatever clarification from the Supreme Court relating to that annexure M other applications. But the order of the apex court is not free from ambiguity. So he will seek for clarification. It says annexure M 38 buildings. Yes. By saying that, no doubt, even if we were to accept that what you say, that's the order, for him to.
Is not.
He's saying only to, no, he's saying that he'll seek for clarification, but he requires. Correct. Till then, what happens? He's saying there's some practical difficulty because getting matter listed in vacation is difficult.
So have to come before the roster and dealing with not this should not run. And once the order comes, the land being regularized, this is my understanding. It means the entire portion of land referred in an incident, which is 5 acres. Then there is no question of them demolishing one outhouse of the security guards and chamber. When the land itself cannot be acquired.
Correct. That we see. That I will not enter into that. So now that's we will only say that till he seeks for clarification in light of ambiguity and give some protection till then.
In all other respects, not the order passed yesterday can be made absolute to that pertains to first act. That my learned friend is fairly simple. This will be in respect to the other 10 that you are please make this.
When does this vacation end?
2nd July.
2nd July. Anyhow, we'll see that is a matter there. The clarification will. Let us see. Let us. But I don't know. But during vacation, division bench, because this order of the committee is by a High Court judge. Some writ was moved before the division bench. But then finally, everything has to be clarified only by the apex. There's no doubt about that legal position. So we will observe that. In the summer vacation, what they did there against the decision of the committee, directly they came to the division bench stating the committee is but the legal position is clear that only the Supreme Court can clarify. So we'll say, and in the interregnum, because of some ambiguity that is pointed out, give him limited protection. The rest.
Is not in total.
But correct. But that will leave it for the Supreme Court. I will not touch anything. I leave all that to be. Now anyhow, he has to move it. He has to move. Yes. Now anyhow, that has been dealt with the committee. Let him seek for clarification. It's the burden is upon him to obtain clarification. Otherwise, you undertake that for some limited period, you will hold your hands. I will. I'll say I considered, and then I asked the BDA, and in light of the impending summer vacation, and I leave it at that. So it will not only be that for them to. Otherwise, you place, we will record the submission that starting of work is going to take some time. And then I'll say that in light of the impending vacation before the Supreme Court, the petitioner seeks for clarification. And in light of your statement is going to take some time, apprehension is taken note of. So that he's actually he remains protected till whatever clarification order is obtained from the Supreme Court.
Area, including 720. But as I think it's not,
The the petitioner has which is your application?
304.
Same which he has given in application. Not something after survey, which has something.
It's 304.
The order sheet. Petitioners have no which application for amendment. Petitioner has filed an application under 151 of CPC read with Article 226 of the Constitution of India. And there is sought for amendment of the schedule. So it is submitted that schedule has been by oversight improperly described, and accordingly the existing schedule is sought to be replaced by the amended amendment. In light of the submission made and amendments of the application is allowed and necessary amendment to be carried out to the petition. The main matter. The petitioners have filed the present writ petition seeking for issuance of appropriate writ in the nature of mandamus, directing the respondent number 2 to regularize the remaining portion of scheduled property, inclusive of land and other buildings covered under 10 pending applications bearing JCC 15-04923. ಅದರಿಂದ ಆಮೇಲೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ ಪ್ರಿಯರಲ್ಲಿ ಇರೋದು till 4936 submitted by the petitioner on 4/8/2021 with annexure Y as per the order dated 6/12/2022 and 3/12/2022 passed by the Apex Court in miscellaneous application number 1614-1616 of 2019, in civil appeal number 7661-7663 of 2018. Petitioners also sought for issuance of writ in the nature of mandamus, directing respondent number 2 to issue certificate of regularization for the entire scheduled property, including land and other buildings and other constructed buildings owned by the petitioner. And such relief is sought for in terms of the order of 6/12/2022 passed by the Apex Court. In the miscellaneous application number 1614-1616 of 2019, in civil appeal number 7661-7663 of 2018. Petitioners also sought for issuance of writ in the nature of prohibition, restraining respondent 2 and 3 from acquiring or taking possession of any portion of the scheduled property, inclusive of land and other constructed buildings, measuring an extent of 5 acres, 36 quintals. It is noticed that the Apex Court, I'll continue at 2:30. Yes. It's better in case.
My lords, seal number 44, my lords.
Yes.
Your lordship may kindly have it on 15th, my lords.
I think once we have heard earlier, I don't know. List the matter on
15th, my lords.
15th.
Much obliged. ಅಜ್ಜನ್ ಮಾಡಿಸ್ದೆ ಈಗ ಎದ್ರ ಹೊತ್ತಿಗೆ ನಾನು
ಬಂದ.
Notice that the apex code in its order of 6/12/22 had passed orders on the 30th report, which report was submitted by the Justice A.V. Chandrasekhar committee, to which committee court had granted, the court had directed that buildings that could be regularized was to be looked into. Next. The apex court in its order on 6/12/2022, insofar as the 30th report is concerned, has made certain observations and relevant extracts of the order as is required for reference in the present matter is extracted as below. Para 9, 10, 11. It is submitted by the senior counsel appearing on behalf of petitioner Sri Aditya Sondi that in terms of the order of the apex court, the 30th report having been accepted and orders passed, it is clear that buildings referred to at annexure M are required to be regularized in terms of the order of 3/12/2020. Attention is drawn to page 0247 of annexure M. And the table, relevant table at annexure M, contains details of the application of the petitioner, which is numbered as JCC-15-04918. And the relevant portion of the table relating to the said application is reproduced as below. Accordingly, it is submitted that insofar as the extent of built-up area of 6485 square feet, as well as sital area of 25,704 is concerned, the recommendations of the committee required to be implemented. Third Senior Counsel Sri Jaikumar S. Patil, appearing on behalf of the respondent BDA, submits that insofar as serial number 2483 is concerned, the extent of built-up area of 6485 square feet was recommended for regularization and necessary orders regarding the same would be passed. However, it was submitted that insofar as the application of the petitioner other than JC 15-04918, namely JCC 15-04923 to JCC 15-04931, sorry, 04936. Applications of the petitioner have been rejected. Next, the senior counsel appearing on behalf of the petitioner submits that the order of the apex court is clear. Insofar as apex court has directed, has noticed that Justice E.V. Chandrasekhar committee had recommended regularization of within inverted comma annexure M 38 buildings, serial number 2378 to 2502. I don't know what that reference, because it doesn't tally with this. Uh, uh, uh. But annexure M buildings, have been recommended for regularization. And further, observations at para 10 of the same order of 6/12/2022 clarifies the matter. It is further submitted that there is a further direction at para 11 which directs BDA not to acquire or take possession of the land/buildings specified at annexure M. And accordingly, the report of the committee must be construed appropriately, and in effect, the buildings in the entire extent of land of 5 acres 6 guintas, 5 acres 36 guintas cannot be touched. However, the senior counsel appearing for the respondent BDA submits that that would not be a correct reading of the order of the apex court passed on the recommendations of the committee in its 30th report. Next, Learned Senior Counsel for the petitioner submits that there must be protection granted in light of the summer vacation to the apex court, and necessary steps would be taken to obtain clarification in light of the contentions of both parties referred to above. Submitted on behalf of the respondent BDA that as on date, the extent of land in survey number 18 is still not ready for utilization, and that the apprehension of the petitioner is ill-founded. In light of the submission of learned senior counsel for the petitioner, that appropriate clarification will be sought for from the Supreme Court. It would be appropriate to dispose of the matter while noticing that clarification would be obtained at the earliest by moving the apex court immediately after courts reopen. Needless to state, in light of what has been stated by the respondent PDA, the court refrains from passing any interim order while making it clear that before any clarification is sought for, if the respondent PDA intends to start civil works, etc., they are at liberty to move this court. Accordingly, petition is disposed of. If the deeds is 2 lakh or 5 acre 36 quintals. 2 lakh 50. It's difficult to get the matters post in the vacation. It's a risk. Designated. And sometimes they say mentioning is also a risk. At mentioning time, suppose you get a worse order than by waiting for the has not. We are still not comment. Property is still and use some appropriate expression.
Okay. Regularization with respect to the tax.
The remaining certificates for regularization. And so far as that item which has been accepted of that 6,400 and whatever, that whatever certificates correct, but so far as that 6,400 and whatever, that unless there is some alteration of the order of the apex court, you will have to give certificate. That's all. Let us see. That's now. Whatever is regularized, whatever, even if it's lesser than that, give it to him, he'll take the benefit of it. And the rest is left open. No, correct. He wants now in his hands. Now I'll tell you. So in another matter, I need to tell you why people are scared of the BDA. I think not that the uh, sale deed is executed after they have acquired in excess. And they have enjoyed and they've also transferred it to others. Then the landowner subsequently files a writ order reconveyance. Then I don't know what happened in that writ. Reconveyance is ordered without reference to this. Though BDA knows. And then BDA in the note says it's a fit case for reconveyance. What happens to the earlier sale deed? So then reconveyance deed is executed.
There are two sets of
Ah.
standing.
So people are a little scared. That image must change of the BDA. At what? At whose cost? Now just imagine that he has paid, that Alati has paid some 8 crores, 10 years. I'm just saying. That's why now BDA will have to start changing its. Number 15. Correct. You will accept notice. This is the matter on each. The survey copy. What? Huh? Ah. The next week we'll dispose it of. Possible to dispose it. Next week we'll dispose. On 8th we'll dispose. Give a memo and let it come tomorrow, day after tomorrow, we'll put it on. No, that's it. Yes. Yeah. Yes. Each. Just 1 minute. Yes. Yes.
Responded. Response verification. Amalgamated with this company with effect from 1/4/2018. Our stand is verified and should be taken.
Yes.
The transactions have an expected the following information forms basis for the notice of the non-compete.
books of the petitioner company. Under the scheme of amalgamation, it stands transferred.
It stands amalgamated and I have already consolidated. Which transactions are reflected in my balance sheet. This is that I have source. That was my response to the notice. Despite that, my lord is kindly seeing annexure F. Page 198. Another notice is issued. Same again in the name of Central Resources Management. Same PAN number. And one more notice. In the annexure page. We do not need again in the name of PAN number. Whatever details I have called for, I have said in the reflected in my discussion. That power. The officer notes that this company has ceased to exist, and all the transactions of that company have been reflected in my books of accounts and returns and expectations just below the table. The notice under section 148A below the table. The notice under section 148A was issued to the SSP on 28/2023. That's the punishment.
Also, okay, you are saying this question of proceeding against Shankar doesn't arise. They should have, if at all, since have taken the stand that it is reflected in the petitioner company, they could have proceeded in accordance with law.
It would not have proceeded even against the petitioner company.
No, that's a different matter. So far as this, that is your case.
This notice information that they have is not the fact that was identified which transactions have been disclosed. Because the entire basis of their is that which transactions are there, we have not filed a return.
No, that will see. Correct. No, that will see. Because finally, if it has to go only on that ground, then issue 148, whatever against the petitioner. That time you place whatever they consider.
No notice can be issued at this because
No, extended time also.
extended time may not obtain because it's not.
No, that will see. Correct. That will see.
Of course. As far as this one, this part.
Correct. You are saying you're agreeing of that same judgment, some other matter. Series of matters, same thing is coming. The authority, not in this matter, forget about this matter, but in many other matters also, where by scheme of amalgamation, merger, the
Compelled to not. Yes. But the assessment is not involved is by 19. But the financial year will be 1/4/2018 to 31/3/2019. The NCLT order was kept in passed on 1860. All these transactions from the effective date of October 2018. All these transactions are done with check of PAN number. Whereas all this information popped up not against that PAN number because not in the system. But the amalgamation information is not there. That's why not is not spending notice the first as well as the notice of issue as per annexure D. If you are spending notice annexure F, that's why you are need what's both the names and both the PAN. But still not. It was not the law letter of the office. Only on that count, that it's under 148 AD and non-existent. But on that ground, you have to kindly watch over 148 AD as well as 148 AD. But keeping in all the sentences of both are permissible in law, if we can make out a point of existence, it will have a lot of
I think some other matters also, same thing, last week.
They cannot provide reopen the proceedings for the patient because subsequent success of the because of the change of the time. This has been this not as of problem, for some people.
It's a technical problem.
Technical problem. That is the reason why second notice. Passing officer, whatever possible, of the different facts. But still, you not, if you can't generate the notice, because the information was included for the balance system. Why that notice amalgamation is not records portals.
Correct, but in 148 AD order, it has been rectified.
Basic details, I think officer has no. The top details.
Okay, what I'm saying, under 148 AD, can you not close it, saying, referring to this? I'm asking, could the, after the 148 AB notice was given and in reply was given, pointing out that this change has occurred. While under 148 AD, when he passes the order, can you not close it?
That's why 148 AD order no mercury.
Right, that you can't. How you can? Correct. Now he has to close it and then initiate afresh in accordance with law against the new company, petitioner company. Can the assisting officer not take such a step?
It is nothing but initiation against the petitioner company.
Let us see that for a moment. The 148 AD order.
AD order. Government can just notice that you are next.
Name of the SSC.
Name of the SSC, Mr. Shankar is also there. Man is also being signed. For that. Just one line.
That will not. That is.
Who was details, but he cannot change it. Whatever the possible it can be made as done. Those two columns will not up to the just about two columns the name of the SSC. That may be some disadvantages for carrying out.
So this is a software issue.
That is how one of the
That will have to be changed.
I have suggested something meeting number more each like that, but that won't satisfy later on.
Which paragraph? Yes. What is the petitioner? As a file represent the petition, seeking quashing of the order dated 28 June 2023. That annexure K passed by the first respondent under section 148 capital A small b within bracket D of the act, rejecting the petitioner's objection as against initiation of reassessment proceedings for the assessment year 2019-20. Petitioner has also sought for setting aside of the notice dated 28/3/2023 at HRL. So pursuant to the order at annexure K. Next, the petitioner day resorts within bracket unless and private has questioned the validity of the proceedings as noticed above. Validity of the reassessment proceedings as noticed above. It is we notice that that amalgamation is at which paragraph you have read? Amalgamation where you have narrated which paragraph? Huh?
First paragraph.
Notice that Shankar Resources Private Limited was a non-banking financial company and merged subsequently into the petitioner company by an order of amalgamation approved by the NCLT dated 18/6/2019 with the appointed date being 1/4/2018. It is submitted that the respondent authorities issued a notice under section 148B, annexure, capital AB, annexure Annexure D on 28/1/23, calling upon Shankar Resources Private Limited to show cause as to why, in view of the details contained in enclosures mentioned, notice under section 148 of the Income Tax Act should not be issued. Petitioner. Now the reply was by an annexure petitioner made out a reply on 4/2/2023, specifically stating that the company to which a notice under 148 capital A small b is to be issued to Messrs. Shankar Resources Private Limited with the PAN number, PAN number, as amalgamated with the Messrs. Coffee Day Resorts MSN Private Limited with effect from 1/4/2018 and so on. Accordingly, it was specifically contended that the company Messrs. Shankar Resources Private Limited ceased to exist from 1/4/2018, and there was no accessible entity by name Shankar Resources Private Limited for the assessment year 2019-20. Various other contentions have been taken on substantive grounds as regards to correctness of issuance of notice under 148 E, which however need not be adverted to in light of the first contention relating to non-existence of Messrs. Shankar Resources so and so, as noticed above. Next. Only on this short ground that the reply not having been taken note of, an order being passed under 148 capital A D AD 148 capital A within bracket D, copy of which is produced at annexure A. Order requires to be interfered in light of the settled during provision. Notice that in the order under 148 capital A within bracket D, the authority has taken note of the merger of Shankar Resources Private Limited with Messrs. Coffee Day Resorts, but as adverted on the merits and concluded, case was made out for issuance of notice under 148. Next. It is a matter of record that as on the date notice under 148 AD was issued. What is that date? First notice in 148 AP. 28/1/23. the entity to which notice was issued was not in existence, having merged along with the petitioner company. Even otherwise, it must be noticed that consequent to the merger, the transactions relating to the erstwhile company, Messrs. Shankar Resources Private Limited, find a mention in the books of the petitioner. In light of the judgment of the apex court. Principal Commissioner of Income Tax, New Delhi versus Maruti Suzuki India Limited, 2019, 107 taxman.com 375 SC. It is clear that the notice and orders passed in the name of non-existing company is a substantive illegality. And is an order passed without jurisdiction. Accordingly, only on the above ground of Shankar Resources Private Limited, having merged with the petitioner company and was not an existing entity as in the date of issuance of notice in the 148A.B. The notice at annexure no, now it, from the notice it will have to go. From the 148A.B. notice. Correct. Accordingly, the notice under section 148 capital A within bracket B at annexure D, comma, the notice under 148A subclause B at annexure F and similar note identical notice at annexure H are set aside, as also order under 148A within bracket small d at annexure K are set aside. And consequently, notice under 148 at annexure L is also set aside. It's needless to state, the respondent authorities at liberty to initiate appropriate proceedings as is open in law and permissible. Insofar as the contents of the notice under 148A small b as against the petitioner company in accordance with law. No, but I'm just asking. Finally, even in spite of the merger, the assessment order of the original entity at some point of time state was there in existence. We say Shankar. Now, in your scheme of arrangement, no doubt there is some transfer, all action must be initiated. But the assessment order which is sought to be reopened is that of Shankar, technically. In effect, though because of the scheme of arrangement, correct, but that is in terms of the scheme of arrangement. No, but to stay, correct, but to stay that that entity doesn't exist, hence you can't initiate may not be a correct reasoning according to prima facie. Now that now Shankar, it is the assessment of Shankar which is sought to be reopened. It may not be in existence then. Now, suppose about within the limitation period about 3-4 years back, some assessment order is passed with Shankar. And then after, within the period of limitation, you come on some information that there has been income chargeable to tax, they are not, then you issue a notice. Technically, the assessment is going to be of the assessment of Shankar. Yes. And eventually, if an order is passed, you're only going to reopen the assessment insofar as Shankar is concerned. Correct. So, but that is only. Correct. But that is only by virtue of the scheme of amalgamation. So to say that it's a non-existing entity, so you cannot with a faulty logic, legal logic, because even if that company is wound up or dead, you go and even if it's struck off, you say struck off from the register of the Companies Act, you still reopen. Don't you? No, I'm saying even as on the date of reopening in 23, even if it is non-existent, would not make a difference because in effect, no, that is there. But I'm saying that because of the amalgamation, you have to do it against this. That is no true. But to say the legal logic, it is not in existence, I can't proceed is false.
That is correct for the act section. Personality of the act itself says that we can't pass
Right of that. Yes.
Is any transaction?
Yes. Next. Cash. ಎಲ್ಲ ಕಡೆಯೂ yes. Next week. Next week. This is the matter. Request next week. Interim direction to continue to the next week. Yes. What is office objection? In the synopsis, date of board resolution is not forthcoming. That is only office objection. Order sheets. That you undertake to. Objection. This is number 1. Is kept in PS. In light of the submission of the petitioner. Consider the petitioner undertakes to comply with the office objection, exceed number 2. Yes. Commercial tax. Huh? EG accepts notice for you. Respondent. Let him take notice. Just look into it. Have it on. Have it on Wednesday and close.
लैपटॉप पे कोड चालू है कोई मुझे देखना
And EG accepts notice for that. Respondent. This is the matter. In the preliminary, we can dispose it of in case your department. Let us see. In the preliminary hearing list on 7th. So you, just orally, in case any precipitative action, you are communicating issuance of notice, let them move on orally. Because he's undertaken to pay, it's a matter of whether he is eligible and you have the power, whatever, that will see. Yes. Office objections. Synopsis and list. Synopsis not in order. Counsel for the petitioner undertakes to comply with the office objections. The appeal. Yes, income tax. Caseless. Who will accept notice? Dilip. Counsel Dilip accepts notice for the respondents. This is the matter. In the preliminary hearing list on, he only wants a disposal anyhow.
That was not, it made functional not get close to 1 year. Now, whatever it has been enabled. Yes. Reference scheme, bypass of those.
That we cannot. That we cannot. Can't jump the queue. At the most, your interim application, whatever.
Clear of that.
But is there no, sir? But there's some circular, isn't it? The fee is pending recovery.
They want to stay over stay. But that is not in priority for us. So, the SSC people must alone.
Correct, but you'll have to wait.
20%.
You'll have to, but you'll have to wait the queue. It has to come chronologically. Correct. Now, what can we do? Now it has to go. Can't come and then get an order by His Lordship's grace and then jump the queue. There are people who are waiting. Final hearing are waiting. We are stuck in B group and preliminary hearing orders on. What I'm saying is that old matter of. So now we can't pass an order that your case be taken out of turn. And that's being strict.
I'm not sure whether it can be taken out.
Then your application for stay can be considered. That's what I'm saying. Then if your application for stay will be considered, you deposit and then you wait a bit. What has happened to your application for stay? So you pay that fee. No, then look into it. Let us. Automatically this. No, paid or recovered? Paid or recovered also. No.
In this case, there is an assessment order, as far as order. The is the nature of the assessment is working for the execution of the law.
Not that council.
That's what I had.
That may be so. No. We are, tax litigation has no equities. We can't give direction. We can't give direction to jump. You pay 20%, we'll pass that on. 20% is paid.
20% because of the financial difficulty
What is the demand? So you pay whatever the 20% there ends the matter. They'll have it next week, you get instruction.
It's less than 20%. But everyone doesn't want to go there. Let it tell these financial difficulties or whatever is there, some authority, from the report like
No, they can't touch it. They can't touch it until let us week after next get instruction. No, nothing. Yes, next.
44, 45 items, 46. Reviewed on.
I appear for the petitioners, my lord.
Just 1 minute. Just 1 minute.
Already the remaining amount is 20% they should not be appreciated.
So you pay it. You orally instruct him to wait for 2 weeks. Let them pay. If they move the matter and we'll close. List after 2 weeks, one date. Orally, you just tell them to wait. Yes. Next.
44, 45 items, 46. Aniruddha or.
I appear for the petitioners in this case, my lords.
Yes.
My lords, in this case, the challenge is to annexure N, which is at page number 195 to 197, which is the levy.
Just 1 minute.
Yes, my lords.
Number
46.
Yes.
Yes, my lords. The challenge is to annexure N, which is at page number, reading paginated 195 to 187, which is the levy of IGST on imported goods. Now, the constitutional validity of IGST is being challenged in this petition, my lords. If I may just briefly narrate to my lords as to how the IGST is levied on imports, my lords.
Otherwise, take out notice.
No, notice and all is taken out. I'm also enjoying an interim benefit.
Pleadings
this is for final hearing.
Yes, pleadings are complete.
Pleadings are complete. Statement of objections also have been filed.
Yes, just one. G1 is not there today because he's not keeping well. We'll have it next week and we'll take it up.
Sure, grateful.
This challenge has not been adjudicated elsewhere.
Nowhere in the country, my lords. My lords, if I may just briefly narrate to my lords as to how it has happened, so that my lords.
Yes.
My lords, customs levy is levied under Article 246, read with entry 83. My lords will have that at ink page 202. Annexure P.
Yes.
Now that is the way customs is levied. IGST, my lords, will remember that the 101st Constitutional Amendment Act had to be enacted, and thereafter Article 269A was inserted. Now IGST is levied in terms of Article 269A. Now 269A clearly mandates, my lords, that only for interstate supply of goods or service, IGST can be levied. Now, under 269A, there is a deeming fiction in the Constitution which says that imported goods, by virtue of an explanation, that imported goods shall be treated as interstate transport, a supply of goods or service, Import of goods shall be deemed to be supply of goods or service in the course of interstate trade. That is how the deeming fiction is. But what they fail to appreciate, my lords, is that the levy under IGST is under section 5. Now, if my lords see section 5, which is at page number 195, if I may just request my lords to take page number 195, because I have never come across a situation where an enactment is given a power to levy and it abdicates that power and gives it to some other enactment. That is what has happened in this case. My lords have page number 195.
Yes.
Page number 195, section 5, the proviso thereof, my lord. Section 5 is not the section in terms of which the levy is levied, but it is the proviso. Now, the proviso says, provided that the integrated tax on goods imported into India shall be levied and collected in accordance with the provisions of Section 3 of the Customs Tariff Act on the value determined under the said act at the point when duties of customs are levied on the said goods under Section 12. Now, this is how Section 195 reads, my lords. Now, if my lords go to the levy of IGST, that how the Customs Tariff Act does that, my lords will find that at page number 198. My lords have that? Page number 198.
Yes.
If my lords come down to the next page, 199, page number 198 is Section 3 of the Customs Tariff Act. Now, 3 subclause 7 is the entry in terms of which this levy is currently levied. 3 subclause 7. Any article which is imported into India shall, in addition, be liable to integrated tax at such rate not exceeding 40% as is leviable under Section 5 of the integrated so and so on a like article on its supply in India on the value imported, whatever. Now, my lords, the question for my lords' consideration would be, now if my lords would just take Article 269A, which is at page number 200.
Yes.
269A. Kindly look at how the article is worded. Also take a look at the next page, my lords, which is Article 246, in terms of which the customs is levied. Now, the question for my lords' determination would be whether under 246, can IGST be levied? Because that is how it is being levied, because it's under the Customs Tariff Act. Now, the Customs Tariff Act has been framed under Article 246, read with List 1, Entry 83, and not under 269A. Whereas the power to levy IGST is under 269A, not under 246, read with List 1, Entry 83. Now, this is in crux the issue for my lords' consideration. My lords, I will go in detail next week. My lords, I just wanted to bring this to my lords' notice because this is
Yes.
in sum the issue involved in this case.
Let us, this is the matter week after next. Date.
It's a very interesting subject, my lords.
Let us see. The matter week after next. Next week.
Would I just request a date, my lords, if my lords don't mind?
15th.
Much obliged. Much obliged.
Big Group Matters, serial number 48. Harish VS. Harish. Forty-nine. 49.
Therefore, if consumer was taken these not paid, these records that's
as per the APS. There is also an accounting standard issued by this account, which requires an account for transactions or leases of particular land. Because it accounts for in accordance with HDFC guidelines and in accordance with this common sense. The auditor has no way of qualifying. But for tax purposes, for normal computation, different considerations apply. So even though income for APS was not accounted for, was offered to tax for normal. In respect of these transactions, the entire lease rental was offered to the normal. What's easy about regular assistance? The officer, after examining all of the intentions, he must tell that I am not entitled to yes, and he therefore brought denied depreciation and also brought to tax to be a part of his revenue also. Now, 4 years after this, what without this, on notice under section 1 of the section, the law taking the depreciation was launched. But since the last year was and the officer that there has been escaping from income on account of failure to dispose of the tax. And accordingly, issued the notice of the reasons probably say that yes, there is your normal computation of that, but for the purpose of computing your income, in terms of section 315, it's an alternative computation under the Act to have not taken into consideration the standard in your regular computation. Therefore, that extent, income is established. Because although I asked the reasons, way back in February, he ultimately gave me the reasons December. That's why Lord is aware. In terms of the judgment and right charges, once reasons are given to an assessment, he has to file his objection against the reasons. When the objections are disposed of, and thereafter, an assessment has to be made, giving an assessee an opportunity to challenge that order or objection. Now, what the officer did here was, he did not dispose of the objection. He passed the final order where not only did he dispose of the objection, but also claimed an assessment. So, therefore, it is said, I challenge the notice and the final order.
Now, this amendment to 148A, I'm saying the amendment making this was in effect bringing this GK and procedure.
Absolutely, it really should statutorily make the in a way. Now, if you want to just say, first let me acknowledge the reason. We see the reasons which are at page 239, next to F.
But if it is so, Arvind, if that is the point of not following the procedure, why do we have to go into much detail then? But we sent back for the.
I was just this one is legal bench of this.
Please.
The assessment will not make this further consistent stand of the government how to explain. It's not a mandate, it's only a directory and procedure. Here, non-disposal of objections are not going to be irregular. Irregularity will not be a fatal
It's not this entire meeting. That has not been accepted. Reasons for the. And the legal opposition was Madras. Madras.
But here now, what is the
Against that order, the SLP was fine with us.
admission?
But SLP said rejected. I submission to my condition that order is unable.
There ends the matter.
I can't buy players. Because of that, it's better. Because the concept of judgment. The judgment of what exclusions. The judgment of this.
Yes. Arvind, they appeared in this,
Yeah, that's what is submitted.
but appeal you didn't go. No, this order is attained finally.
Some income was very
So you are
thousands of.
paragraph?
That those cases were discussed. Accommodation and
Paragraph? Yes.
Question concerning the record. This record was obligating the part of this. This whole objection from important reasons. Not to obviously. Facts, there is under. What's the set of the facts? But then paragraph 8. As such in our view, the question involved is no more risk. It's covered by a decision apex court that is this court. In case of GP and drive shafts, whether the apex court taking a decision instead of the court's action, the part of the apex the apex court at para 5 internally observed as under. However, it clarified that when a notice under 148 of the Act decision, the proper course of action for the noticee is to file return, and if he so desires to reasons for the issuing of notice, the officer is bound to furnish the reasons within a reasonable time. On receipt of the reasons, the noticee is entitled to file objections to issuance of the notice, and the assessing officer is bound to dispose of the same by passing a order. The aforesaid shows that if the assessee desires reasons for issuing the notice, the assessing officer is bound to furnish the reasons, and upon the receipt of such reasons, the assessee is entitled to file the objections to the issuing of the notice, and the officer thereafter is bound to dispose of the same by passing a speaking order. It is only thereafter that the assessment may be reopened in accordance with law, unless there is any prohibitory order of the competent forum. A reference will be made to a decision of this court in Vardhaman Metals, wherein the learned civil judge had more or less taken a similar view. The dismissal of the appeal on the ground of existing alternative remedy, and the matter was carried in appeal before the court of writ appeals. This court, by relying upon its earlier decision, writ appeal number so observed in para 8 is under. This is an appeal filed by the assessor against the judgment and order dated 11 December 2014. Passed by the learned civil judge in WP so wherein the petition challenging the notice of 148 has been dismissed on the ground of availability of alternative remedy. Once then, they have extracted from the judgment, my lord. And then, if my lord would just see para 5 of that judgment, we have heard the learned counsel for the parties and produced the record. The question of non-furnished the reason for reopening has already concluded. Assessment goes to the very root of the matter. After filing of the return in response to a notice in the 148 or on request of the SSC requesting the return of income, initially filed be treated as a return of income filed in response to such notice, the SSC is entitled to be furnished the reasons for such reopening, which can also be challenged independently. Since such reasons are not being furnished to the appellant, even though a request for the same has been made here of the opinion that proceedings for reassessment could not have been taken further on this ground alone. Besides this, it is not disputed that the statement of some other person which was recorded in the appellant was asked to explain the same for itself not furnished to the appellant assessment. As such, besides non-furnishing of reasons for reopening, there was gross violation of the principle of natural justice. In view of the aforesaid order, we are of the opinion that the writ petition against the reassessment order ought to have been entertained, and the dismissal of the writ petition on the ground of availability of alternative remedy was not justified in the factual case. Since you are of the opinion that the reopening of the assessment of the 148 issue of the act of itself valid in law, we set aside the order passed by the court as well as the reassessment order later. So, accordingly, this appeal as well as the writ petition stand alone. Then, my lord, this is para 5 of the current judgment, para 11 of the current judgment. If the facts of the present case are examined in the light of the aforesaid legal position, it is an admitted position that the reasons for reopening of the assessment by issuing of a notice under 148 was supplied to the appellant assessor. It is also an admitted position that the appellant assessor, after receipt of such reasons, raised objection. It is also not the undisputed position that the assessing officer did not dispose of the objections prior to proceeding with the assessment further and proceeded to pass the order of assessment. Under these circumstances, it can be said that the mandatory procedure of disposal of the objections by the assessing officer before proceeding with the assessment has not been followed, and the exercise of power can be said as not only vitiated, but the order of assessment cannot be sustained. If the decision of the assessing officer is illegal on the face of it, in our view, it would fall in the exceptional category of making a departure from the normal principles of a self-imposed limitation of not to interfere in a matter where there is existence of alternative statutory remedy. In view of the aforesaid, the impugned order passed by the learning civil judge is set aside. The impugned order of assessment is also set aside. It is observed that the officer shall be at liberty to proceed in the matter in accordance with law. Appeal is allowed to be aforesaid extent. And this principle has been followed thereafter by the learned civil judge. The emphasis.
But finally, in this order, it says that the assessing officer shall be at liberty to proceed in the matter in accordance with law.
Accordance to law, whatever he can do in law, he can do it.
He cannot do it.
Now, limitation is against. Limitation is against. This is assessment year 11-12. He reopened on the last day. Because at that time, limitation was 6 years. Because I have several grounds. Because one of my grounds is the notice has to be issued within 6 years. The notice was received by me on 5th April. It was sent to me by an email on 10th April. So that itself shows that it was not issued by 31st of March. That's one of the grounds. One of the, I say, there are several grounds in this matter.
So finally, it says the assessing officer is liberty to proceed in accordance with law. We'll say that and leave it at it. Now, what is the, let us see what the Madras High Court.
what to do. Order is passed for following. An order is passed for following. It is a mandate. Again, a switch from another statement, say, statement was taken up for another situation.
No, but Madras one also, even if you give liberty, suppose court gives liberty. I'm just saying, suppose the court says the assessing officer is at liberty to take proceedings relating to the notice. It should be construed in accordance with law. No, so if that were to be so, even in the Madras case, if it's barred by limitation, he cannot.
So that is with reference to the investigation. But what Madras High Court, Madras High Court is, arrangement is while redoing about the compliance of GK invitation is expected. But here, but because there were two issues, non-compliance of GK shops and the limitation before Madras. Because in the first ground, the land was sent back. Second issue was kept. Whereas in the measurements of this order also, but proceedings were quashed in the entirety. For non-compliance GK. And liberty is not allowed. You open up.
The second bench says, assessing officer shall be at liberty to proceed in accordance with law.
Once 1.8 is set aside, adjudication in terms of GK is second stage.
It has to be redone by fresh notice.
Itself was quashed there. Then we have to 1.8 has to go with 1.9.
That's why you get a stay. That's why in such proceedings, there has to be a stay. Otherwise, the whole thing washes out. Now, what are the, just now give me the.
On the submission, another view taken very little. Madras, I realize it is 26 and
But it's
80, 90. I think around 90. 54, 26.
finally, even the Madras one, that issue will have to be confronted when he starts the proceedings. Here, did they keep the 148 intact? No, did they? Was not caused.
Even let us assume that you cannot set aside the assessment. But at that time, person also has necessarily not deal with the verification. Which one elected is campus that what is what dispatch after 31st March. That one remains to be not but it needs to be more in terms of. That was the situation we had in practice.
Now, what is the reference to non-disposal of objection? Just take me through the relevant.
My lord will just say, my lord's page 206 the notice. Mention D.
31/3/2018.
Whereas I have reason to believe that income chargeable to tax for assessment here is estate assessment. Within the meaning of 147, I therefore propose to assess reassessment. This was 31st of March. But on 27th of April, my lord will just see page 207. I write to him.
Yes.
I will just see the paragraph beginning in the present. Let me read this one. It's a short letter now. We refer to the notice dated so issued by Cooperative under 148 received by the company on 5th April 2018. Thereby, you have proposed to reassess the income with respect to assessment of the employer. In this connection, we refer to the discussion we held with your Cooperative on 16th April, where we requested to kindly furnish the reasons for initiating reassessment company under 147. We further submit that the return of income for the said year under 139 be treated as a return of income filed in compliance with the aforesaid copy of the return of income. Without prejudice to the above, we also wish to bring your kind attention that pursuant to the first proviso of section 147, where assessment under 143 has been carried out, no proceedings under 147 of the Act can be initiated after the expiry of 4 years to the end of the relevant assessment year. The present case we submit the following. Company filed the return of income under 139(1) on 30th November along with tax audit report. Assessment proceedings under 143 were completed by order dated 30th March. Notice under 148 initiating proceedings under 147 were served upon the company on 5th April. At the time period for initiating the reassessment proceedings under 147, pursuant to the first proviso under 147 expired on 31st March 16. That is 4 years from the end of the assessment year ending on 31st March 12. Consideration thereof, we request your good self to drop the proceedings initiated in their good office, proceedings being time barred on account of the statutory limitation period. Then, my lord, he doesn't do anything till December. My lord will then turn to page 239. This is a letter dated 18th December 2018. It's a notice under 142(1).
Page
239.
Yes.
And he gives me the reason that my lord will close para D at page 240. Copy of the reasons for reopening the assessment is also attached here for ready reference.
Yes.
He gives me the reasons after more than 8 months. And if my lord turns to page 242, the reasons are there. Just see the reasons at page 242. The SSC is a private limited company. SSC has filed its return of income for assessment at level 12 on 30th November, declaring a total income loss of so-and-so under normal provision of the Act, the income of so-and-so under section 115 JD of the Act. The return was duly processed in the 143
1 and an order under 143 was completed on 30th March 15, assessing total income of rupees so under normal provisions and book profit under section 120 JD at rupees so. In the above case, assessment for 11-12 was completed after scrutiny, wherein a book profit of rupees so was charged to tax. It is seen from column number 11A of the PCT report that the SSC company is preparing accounts on accrual basis, except overdue installments of these rentals, hire purchase rentals are recognized on cash basis as per the prudential norms issued by RBI for NBFCs. In this context, it is observed from a statement of computation of income that while computing income under normal provision of the Act, in consonance with the disclosed accounting policy, SSC company had made an addition of rupees so towards income from NPA on lease and hire purchase and income from NPA on loan respectively. Further, a net addition of rupees so lease rental minus interest was also made in respect of actual lease rentals accrued during the year. Thus, it is quite obvious that the aforesaid income, which was required to be routed to the profit and loss account, was not credited to the profit and loss account. Accordingly, in terms of the legal provisions cited above, the said income not credited to the P&L account was required to be added back to the book profit. However, this was not done. The above omission may have resulted in under-assessment of book profit by rupees so. In this case, more than 4 years have lapsed from the end of the assessment year under consideration. The SSC has not disclosed fully all material facts necessary for assessment by not crediting the above mentioned accounts to its P&L account. This has led to an income of so and so escaping assessment, hence necessary sanction to issue notices of. So he picks up everything from the accounts only. Where is the question when he failure to disclose? Anyway, I then filed a reply to this. Please see my objections at page 246 annexure J.
Filed on 24th December.
That's right.
And he doesn't pass an order on this.
He doesn't pass a separate order, he passes the final assessment order, which my lord will find is at page 260, dated 30th December.
Annexure K.
Annexure K. Point is, limitation was running out. Limitation expiring on 31st of December. Because he sits on it for 8 months, doesn't give you the reasons.
So now insofar as consequence of not disposing of the objections, there is no apex court judgment on that.
But the DB, there are other high courts, I did not keep it because really the DB today is there. There are subsequently several single judges which have also taken the same view.
Petitioner.
We'll just keep all other issues open because in case he passes a fresh order, because I have various other contentions, it should not be that I have not considered before.
So he will still.
Yes, he does. We don't know what he does now. Or if they go to the Supreme Court and get it reversed, we don't know what they will do.
Here is at page.
One of my prayer was. What's page 22, 21? Oh, sorry, bottom of page. The petition therefore pays on the
Petitioner has sought for declaration that the interim proceedings initiated by the second respondent and continued by the first respondent under section 147 and with section 148 of the Act are barred by limitation and opposed to the barred by limitation, comma, has sought for quashing of the notice dated 31/3/2018, issued by the second respondent under section 148, 147 of the Act, GK and Drive Shafts. GK and Drive Shafts. 2002, 125, taxman 963, अथवा 259, IPR 9. Respondent under 148, 147 of the Act, the assessment year 2011-12, comma, and also challenge the reassessment order dated 30th December 2018 that action K passed to the first respondent under 143 section 147 for the assessment year 2011-12, comma, has challenged the consequent demand notice dated 30/12/2018 at annexure L, and the notice dated 30/12/2018 at annexure M with the first respondent. The petitioner had filed its return of income for the year 2010-11. Declaring a loss and computing the same under section 115 JB of the Act. Next. One 143(2) is
143(2) notice is in jurisdiction to make a 143 assessment. 143(2) is a notice asking me to give details in support of my return. That's next it was noted. 142(1) is where he asks for various particulars.
second respondent had issued notice under 142, which was responded to by the petitioner, and an order came to be passed under section 143. Subsequently, on 5/4/2018, petitioner received a notice on 31/3/2018 under 148 of the Act by the second respondent proposing to reassess the petitioner for the assessment year 2011-12. The petitioner had filed its response to the aforesaid notice, objecting to the initiation of proceedings, and petitioner had called upon the second respondent to furnish copy of the reasons recorded for initiating the proceedings. The first respondent furnished copy of the reasons recorded for initiating the proceedings and sanction granted by the Principal Commissioner of Income Tax for issuance of notice by way of annexure F and G. Next. The first respondent subsequently issued notice under 142 of the 143(2) of the Act calling upon the petitioner to furnish documents in support of the income filed by it, to which the petitioner had filed its objections to the initiation of the reassessment procedure. Next, the respondent has passed an order under 143 read with section 147 of the Act, recomputing the total income of the petitioner. Next, the senior counsel appearing for the petitioners submits that the matter is to be disposed of on the short question relating to on the sole ground that the procedure prescribed in GK and drive shafts versus ITO 2002-125 taxman 963, which requires that reasons for issuing notice once communicated and objections received, if the same are not adjudicated upon before reassessment order is passed, then the proceedings of reassessment requires to be set aside. Third, senior counsel appearing for the petitioner submits that admittedly, in the present case, after the reasons for reopening have been communicated in terms of Annexure F, and reply was made out by the petitioner in terms of Annexure J, without disposal of the same, the question of passing reassessment order under 143(3) would not arise. Read with 147 would not arise. And that in light of such lapse, the legal consequence would lead to setting aside the reassessment order under 143(3), read with section 147, while placing reliance on the order of the division bench in Deputy Commissioner of Income Tax in Deepak Extrusions Private Limited versus Deputy Commissioner of Income Tax, Central Circle, 2017, 80taxman.com, page 77. This specifically asserted that the non-compliance of the procedure provided in the GK and drive charts, insofar as the stage of passing of order on the objections filed by the petitioner, and if the assessing officer proceeds to pass the reassessment order without passing orders, then such an illegality is to be visited with the consequence of quashing the notice, quashing the reassessment order and question of keeping open any other right by enlarging period of limitation for issuance of notice under 148 would not arise. And Counsel Sri K.V. Arvind would submit that The judgment in GK and drive shafts merely lays down a procedure to be followed, and if such procedure is not followed, it would not have the effect of taking away the substantive right of the authority, and submits that in the event the procedure prescribed under GK and drive shafts is not followed, as in the present case, the notice under 148 requires to be protected while directing the assessing officer to redo the procedure after following the procedure as laid down in GK and drive shafts, and relies on the judgment of the Madras High Court of Madras, in the case of Home Finders Housing Limited versus Income Tax Officer, 2018, 93 taxman.com, 371, Madras.
This another key judgment subsequently, where they consider Madras and the second one. This is para 5 of this judgment. Substance revenue states the reasons are made known to the assessor or the etc. The assessor cannot file objections of reasons only during the hearing on 18 December 18. Thereafter, the assessor filed its objection and the scene was discussed and the assessment order was passed. According to him, it is a curable defect under 292B. Basic reliance on home finders is submitted by the Madras High Court in the said case and demanded the matter to AO. He submitted that the SLP filed against the said order as we discussed. With these observations, he paid for allowing the appeal. However, then the SSC response to this. So, Surabaya, though he did not discuss with the case of home finders, the matter was demanded, submitted that as held by this court in Deepak, the mandatory procedure for disposal of objections by AO. Before proceeding, the assessment has not been followed. He argued that the said finding has been given after consulting the authority of GKN. In view of the authority of exclusions, this appeal does not merit any consideration. There are no extraordinary reasons to remove the constitution. Yet consider the rival submission to remove the record, but when they set out the facts of that case, but will then just see paragraph 10. The main contention urged is that it is a curable defect in the Honorable Gujarat High Court at Banaskantha, and the Honorable Madras High Court in Home Finders have remanded the matter to AO for reconsideration. They record that this court, by following the authority in GKN, has held that the procedure is mandatory. The dates and events recorded by us hereabout clearly indicate that from April 18 to 18, the AO has not taken any action, which is more or less similar in the case of Deepak exclusions. Single judge has rightly noticed para 8 of the meeting order that by no stretch of imagination, it could be held that the order is passed by the AO, considering the objections faced by the SSC. The writ petition has been allowed by following the restrictions. This is an intra-court appeal. No basic error to interfere with the taken by the judge. Also, when the division bench of this court, following the authority of this court, has held that the provision is mandatory.
The Learned Senior Counsel applied for the petition also relies on judgment of the division bench. Writ appeal 919 of 2019, disposed of on 24th of January 2023, between the Assistant Commissioner of Income Tax versus Messrs. Memphis Limited, wherein the division bench has again reiterated the conclusion in Deepak exclusion, while observing that the procedure in GK and drive shafts is a procedure that has been held to be mandatory. And accordingly, the division bench had rejected contention raised by the revenue that the judgment in home finders ought to have been followed. Heard both sides. It is not in dispute that the apex court in the case of GPA and drive shafts has laid down procedure to be followed. In a notice under 148 of Income Tax Act is issued. The procedure that is envisaged is as follows. Extract one. We see no justifiable reason to interfere with the order, the challenge. And in the whatever. Next. It can also be taken judicial notice of that this procedure has been insisted for strict compliance wherever matters have come before the court, violating the procedure laid down by the apex court to be followed in case of section 148. In the present case, it needs to be kept in mind that the proceedings under 148 will have the effect of reopening the assessment. It is in this context the court has to decide while construing the effect of non-following of the procedure under GKN drive shafts. Next. Admittedly, the reasons for reopening having been communicated as per Annexure F and reply to such reasons having been furnished by the petitioner, the assessing officer is bound to dispose of the same by passing a speaking order. Before proceeding with the assessment in respect of the year with respect to which notice under 148 has been issued. The reassessment order has been passed at Annexure.
Second order is Annexure K.
Assessment order under 143.3.
That is 147.
With section 147 has been passed on 30th/12/2018. That was the last date of limitation.
31st.
In light of limitation expiring on 31/12/2018. The practical difficulties of the assessing officer would be no reason to condone the non-adherence to the procedure in GK and drive shafts. The effect of not following such procedure has been dealt with by the judgment of the division bench of this court in Deepak Extrusions. Wherein this court has rightly, where the division bench of this court has rightly held that the mandatory procedure of disposal of objection by the assessing officer not having been followed, the order of assessment cannot be sustained. If that were to be so, and the assessment order had under 143(3) read with section 147 requires to be set aside. Question of preserving the notice under section 148 would not arise. The contention of third Counsel for the Revenue, Shri K.V. Arvind, relying on the judgment of the Madras High Court, cannot be accepted in light of the declaration of the division bench in the case of Deepak exclusion, stating that the procedure prescribed in GKM drive shafts is a mandatory procedure which would vitiate the assessment order, and same having been concurred with another order of the division bench in writ appeal 919 of 2019, disposed of on 24th January 2023. Next. It is neither, it is impermissible for this court to accept any argument and pass orders contrary to that of the division bench orders referred to above. Even otherwise, if perusal of the observation made by the apex court in GK and drive shafts clearly specifies that clearly records a finding that the assessing officer is bound to dispose of the objections filed by passing a speaking order. Accordingly, the order of reassessment dated 30th December 2018 is set aside. Is quashed. The petition is disposed of accordingly. Yes.
Consequent demand notice also.
Consequently, what are the consequent annexures that have to be set aside?
Annexure, part of annexure K. K and L, my lord. Just see Roman 4 at page 20. But really there is 148 of the demand notice that annexure L, page 266.
Accordingly, Roman
2, 3, 4, and 5. If my lord just gives here's Roman 2, 3, 4, and 5 at page 20.
accordingly, notice. Once Roman 3 is allowed and the assessment order under 143(3) then is quashed. Consequently, the demand notice dated 30th 2018 as well as notice dated at annexure L as well as the notice dated 30/12/2018 at annexure M are set aside. Now, just one minute, I'm just asking you, suppose we set aside the assessment order and these consequential demand notices. Should we again set aside the 148?
Yes, my lord. Consequence has to go, man.
Because consequence has to. Both nothing can be done, sir. Need to not complete of
The notice in the 147 read with 148. 148.
The notice is under 148.
Notice under 148 also set aside. Now, GK and drive shafts, we have made it in all case whether as mandatory only we have followed. Yes,
But from the fantastic.
correct. But now if you look at the new provision which
That's really statutory makes it mandatory. What was earlier judgment law?
and that has been followed. Yes. Sometimes I ask questions because I'm not familiar. So I'll ask questions. Bill number 58, we listed in the orders list. We have it on Wednesday, Thursday.
Number 61.
50. This is the matter in the orders list. On 8.
All sure order. So can be taken with caption order. So let's say order.
One listing. No, interim order is not considered.
You can still go back there on the violation.
It's the matter in the preliminary hearing. On
Also,
no, the tax roasted evening. Wednesday or Thursday. On 149. Capital gains. Capital gains.